What is one of the biggest misconceptions about depositions in a civil lawsuit involving a medical malpractice case, an accident case, or a wrongful death case? Would you like to know the answer? Come join me for a walk around the neighborhood as I head to the train and head into the city, as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. One of the biggest misconceptions that injured patients and injured victims have is that they think that when they bring a civil lawsuit, and now it's time for them to answer questions by the opposing attorney in a process called the deposition, which, by the way, is nothing more than a question and answer session that's given under oath, and typically takes place in your attorney's office, at least pre-COVID. Nowadays, it typically takes place on a Zoom video call. Now, importantly, you should know that the answers that you give represent your sworn testimony, and even though you may be doing this on a Zoom video call, carries the same exact weight as if you are testifying in court, at trial, in front of a judge and in front of a jury. Okay, so let's get to the question I raised. What's the biggest misconception that injured patients and injured victims have when giving a deposition? The biggest misconception is that these injured patients and injured victims think that the deposition is an opportunity for them to tell the other attorney, the opposing attorney, every single detail about every single event that happened in their particular matter. That's the misconception. Now, why is that wrong? I'll tell you why it's wrong. Because a deposition is nothing more than an opportunity for you to answer the opposing lawyer's questions. That's it. So, for example, if the opposing attorney says, "What was the weather like on the day of the incident, on the day of your accident?" That doesn't call for a 10-minute explanation about what you were doing leading up to the incident. It simply calls for, what was the weather like? Oh, it was beautiful, it was sunny, it was 85 degrees. If you notice, I'm wearing a jacket today. It's kind of chilly as I'm heading to the train. All right? It's a simple, straightforward question. And today I'm going to be doing a deposition of my client who is significantly injured by a careless doctor and hospital staff. And now there's going to be an opposing lawyer who represents the doctor and the hospital who's going to be questioning my client for many, many hours today. And one of the most critical things to get someone to understand, especially my client, is, listen, this is an opportunity for you to answer their questions. And the typical response is, well, what if they don't ask me about this? And what if they don't ask me about that? Well, in that event, then they lose out. Why? Because that means that they will have lost an opportunity to ask you critical questions that may, in fact, be important for their defense. It may be important for them to learn, in your own words, exactly what happened to you. And if they fail to ask certain questions, it could mean a number of things. Either the attorney forgot to ask a critical question, or the attorney was inexperienced and didn't know to ask certain questions. Now, I will tell you that that typically doesn't happen. However, it is critically important that you, as the injured victim, as the injured patient, pay attention to the question that is being asked. So here's a perfect example. If the opposing attorney says, "Hey, what's the color of your jacket that you're wearing today?" They don't want a 5-minute explanation about where you bought the jacket. They don't care why you chose to wear that jacket today. They don't want to know whether it's a thin jacket, a heavy jacket, for what type of weather. They only asked you a simple question. What is the color of the jacket that you are wearing? Oh, in this case, it's a blue jacket with some dark blue and then some white. That's it. If they want to know additional questions, I guarantee you that they will ask you additional questions about whatever it is that they're asking. They will ask many, many follow-up questions. So if you were to give explanations about every single question that you are asked, you would be there for days. Absolute days. Why? Because now you're adding significant time to something that was not asked. And if they don't ask about it, then you should not be answering that information or providing that information. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into how these types of cases work here in the state of New York. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is get out of the road so the cars don't pass by too closely, and you have questions that still need to be answered. What I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.